All right. Let's have order in the court, please. Order in the court. Thank you. Thank you very much. Proceed, Mr. Miller, please. Thank you, Judge. Good afternoon, Mr. McCaskill. Good afternoon. I still have you under cross-examination. I shouldn't be too much longer. I don't think Mr. Rainier covered this in his direct examination, but the jury has heard from other cooperators along these lines. Sir, is it your hope that by cooperating in this case and in the state court matter, that the government's going to file a Rule 35 motion on your behalf in an attempt to reduce your 80-year sentence? Yes. Okay. And unlike some of the other cooperators who have testified before you, objection to relevance, rephrase your question. So, I'll just get to the point. Your sentencing judge is Judge Zaney, this man right here, correct? Yes, sir. And you know that to be the case, right? Yes. So, what I understand from Rule 35 motions and the Rule 35 practice, and correct me if I'm wrong, but sort of the golden rule for someone who's seeking a Rule 35 time cut is to tell the truth before the judge that ultimately imposes his sentence. Do you understand that, sir? Yes. So, you understand, in order for your Rule 35 to be successful, you need to tell the truth in front of Judge Zaney. Yes. Sir, during the lunch break, we all sit back and reflect and think about things. I put this exhibit back up on the screen, and I want to give you the opportunity to complete this by adding any additional murders that you were involved in, or shootings or stabbings that you were involved in, to make sure that we have complete and accurate record before Judge Zaney. Okay? And just take your time. Take as long as you need. And just let me know if it's complete or if we need to add something. And if we do, we'll add it. Probably shooting. Under shootings? Yes. Probably on Fluid Street. I'll mention that. I mean, I don't think I hit nobody. I don't know if I hit somebody. So, that's something Mr. Rainier covered in his direct examination? Yes, I think so. And those victims would have been Al Hardy. Are you familiar with that name, sir? Yeah, I'm familiar with that name. I ain't familiar with nobody else's name besides Al's. So, what I'll do here is I'll just put on Fluid Street victim. Are you okay with that? No, I'm not okay with that because no Fluid Street victim was in the line of my fire. The only one that was in the line of my fire was Al and the dude on the court. Okay. I'm aware somebody else got shot, a lady or something, but she wasn't in my line of fire. All the ladies was to the left, and only dudes was to my right. Okay. No, look. It's your opportunity to make the list up as you wish. I don't want to put words in your mouth. So, anything else, or do you believe it's correct now? I guess so, man. I said, I guess so. You're good with this as being true and accurate to the best of your recollection? Yeah. Okay. And, sir, I just want to make sure, testifying today, you're not under the influence of drugs or alcohol that would impact your ability to testify truthfully or to remember facts, correct? Correct. Now, sir, with respect to some of the names on this list, Michael Marshall, do you see that one, sir? Yeah. That was the DEA informing that you shot and killed, correct, sir? Yes. And you shot him with an assault rifle, correct, sir? Yes. And you blew his brains out, correct, sir? I guess so. And you blew his arm off, correct, sir? If you say so. I didn't examine the body after it happened. We moved around. Yes, sir. I was going to ask you that. Between the time, and you said you unloaded an entire clip on him. Is that correct? I didn't say entire clip. I said I shot until it was empty. Well, how many rounds do you think in total you shot that day? I can't tell you. At Michael Marshall, if you can tell me. I can't tell you, because I'm never on the discovery since this case been going on. The only thing I'm on is my plea agreement and the factual basis. So, as I understand your testimony on direct examination, You emptied the clip on Michael Marshall, and then you saw an 18-wheeler with 2 Mexicans in it? Yeah. And you were, I assume they was Mexican. I can't say what they was. They looked Mexican. Okay. And you were concerned that these 2 individuals in the 18-wheeler had been witnesses to you shooting Michael Marshall? Yeah. And so you held the AK-47 up at them so that they could duck and not, so that they weren't able to better identify who you were? Yeah. Okay. Now, just going off this list again, you testified earlier that 3 of these murders you pled guilty to in state court. Do you recall that testimony, sir? Yes, sir. Can you identify which ones, for the record, on Jasmine Perry Exhibit 6? Which murder victims did you plead guilty to in state court? Charles Anderson, Lester Allen, and Lester Foster. These 3, sir? Yes. So on the list, it would be numbers 3, 4, and 5? Yes. Now, I understood your testimony earlier today that in connection with, I just want to make sure that I understand it and the jury understands. You did a global plea agreement. You did a plea agreement to resolve your state court charges at the same time or in the same documents that you did a plea agreement to resolve your federal court charges. Correct? Yes. And in the course of pleading guilty in state court, the actual charge at the end of the day that went towards your 80-year sentence in state court was that you actually pled guilty to the manslaughter of these 3 individuals. Correct? Yes. So, you didn't plead guilty to first-degree murder. Correct, sir? No, sir. And you didn't plead guilty to second-degree murder. Correct, sir? No, sir. And, sir, you understand, under Louisiana law, first-degree and second-degree murder charges carry mandatory life sentences. Correct, sir? Yes. So, by reducing these 3 murders down to manslaughter, that's what enabled you to get an 80-year sentence in state court. Correct, sir? Yes. Thank you. Excuse me. Yes, sir? You asked me, did I have something to add? I would like to add one more under shootings and stabbings, now that I think about it. Alright? Sure. Burnell Allen. Okay. I think that's one of the counts I pled to the attempt. Burnell. I think so. I think that's it. Allen. Correct? Yes, sir. Okay. Sir, again, I don't want to rush you. It's very important that this document be accurate. Anything else you can think of that would fit on this document? Not right now, sir. Okay. If you think of anything, do just like you did a minute ago. Yes, sir. Just stop me and say, I thought of something, and we'll get it on there. Let's talk a little about Charles Anderson, okay? Alright. His nickname was Buck, right? Yeah. And as I understand it, the reason why you killed Buck was because the day before you killed him, he had been involved in the murder of the little girl, Kiera Holmes. Is that correct, sir? Yes, sir. Okay. And the reason why you killed Buck the day after he was involved in the murder of Kiera Holmes is because you and others considered Buck to be a weak link. Correct, sir? Yes. And by weak link, what I mean is you were concerned that if, well, let me back up a second. In your direct examination, you mentioned that Buck had a unique vehicle. Do you recall that testimony, sir? I don't think I said the word unique, but I recall him having a vehicle. I'm paraphrasing. Describe for the jury Buck's vehicle. It was a Tahoe with rims on it and sound in it. Did it have big pipes? Yes. To blow out a lot of sound? Yes. Okay. And that's what sort of made Buck's truck remarkable, correct? If you say so, sir. Well, it wasn't stopped. He had tricked it out. I mean, it was nice, right? It was unique. different. Is that right? Yes, I guess, if that's what you call unique. The rims and the pipes on that Tahoe made it different from other Tahoes that come right from the factory. Right, sir? Yes. And, sir, is it true that in the aftermath of Kiera Holmes' murder, it was a very high-profile case? Correct, sir? Yes. Because she was an innocent little girl killed on the stoop. Correct, sir? Yes. And so, it was all on the TV news. It was in the newspaper. Her murder. Correct, sir? Yes. And prior to killing Buck, some of the information that came out about her murder was the identification by some eyewitnesses that Buck's truck, this Tahoe with the pipes and the rims, was spotted near the scene of the Kiera Holmes murder. Correct, sir? Yes. And that was an important clue to the public, to the police, as to who may have been involved in Kiera Holmes' murder. Correct, sir? Yes. And that concerned you that information had gotten out about Buck's truck being involved in the murder of Kiera Holmes. Correct, sir? Yes. And so, you were concerned that because someone or some people had identified Buck's truck as possibly being involved in the murder of Kiera Holmes, that someone would see that truck on the news or on the internet or on the newspaper and call Crime Stoppers or call NOPD and say, "Hey, I know the owner of that truck. It's Charles Anderson." That's what concerned you. Correct, sir? Not really. What concerned me is that after he did it, he didn't tell me what he specifically did with the truck or in the truck, and I was last seen in the truck. Okay. And the truck had been in the news in connection with the murder, right? Yeah. I saw that after, after. It was after I had to ditch the truck and went inside and looked at the news. So what you did because of this truck being a clue to the murder of Kiera Holmes and Buck being known as someone who was weak, you killed Buck. Correct, sir? Yes. And you did that, sir, because you were concerned that either the information about Buck's truck or Buck himself being interrogated by the police would then implicate you in criminal activity and cause you to go back to jail. Correct, sir? Yes. And you didn't want to go back to jail. Correct, sir? No. And so you followed the news about the murder of Kiera Holmes. Correct, sir? Yes. Can you identify for the ladies and gentlemen of the jury if that, in fact, is a photograph of Kiera Holmes? Judge, I'd object to the relevance. I don't know how she looks. Overruled. Go ahead. Yes or no, sir? Do you know who that little girl is on the screen? I didn't guess, sir. I said no. I don't know who it is. Alright, next question. You're aware, sir, that Kiera Holmes was a 2 or 3-year-old little girl, correct? I'm aware she was 24 months, yes. So that would have made her 2, correct, sir? Yes. So, sir, instead of allowing the police to interrogate Buck and perhaps solve the murder of Kiera Holmes in a matter of a couple of days, which would have given closure to the little girl's family, to the community, objection, Judge. Speculation. Sustained. Well, it's not speculation. We don't need the narrative, Mr. Miller. Sir, you didn't want the police to interrogate Buck, Charles Anderson, in connection with the Kiera Holmes incident. Correct, sir? Objection. Asked and answered. Sustained. Let's move on. Sir, after you murdered Charles Anderson, do you know how long it took the police to arrest the suspect in the murder of Kiera Holmes? Objection to relevance. Overruled. I would say that it's the same day, or the same day after Buck was killed. Sir, you've been charged and you've pled guilty to manslaughter for the murder of Charles Anderson, Buck. Correct, sir? Yes. Have state or federal authorities ever brought obstruction of justice charges against you for your role in trying to cover up the murder of Kiera Holmes? No, sir. Alright. Thank you for that, sir. Sir, have you thought of anything else that would go on this chart? No, sir. I'm going to go ahead and hand this back to Mr. Cole. If you think of something, because he keeps the exhibits. If you think of something, let us know. Okay.